Hey guys, it's Kathy. I hope you're doing well. No camera today. I found out who was boss, and it's definitely my computer. I don't know why. It's just not this. It's the software program that I use to stream. It just can't find my camera. It was right there yesterday, or yeah, yesterday, but it's not there now. All right. So, oh wow, it looks like my Wi-Fi is not very strong tonight. Yeah, it's gonna be a night, guys. We'll get through it. We'll just play some court videos and that'll work. Let's start with this poor guy. This is in Florida.
Wade Gale.
Good evening.
Good afternoon, sir.
Yes, ma'am.
All right, sir, you are here, possession of a firearm by a convicted felon.
Mm-hmm.
I do find probable cause for your arrest. You do qualify for the public defender. So I'm going to appoint the public defender to represent you. I'm going to set your bond at 15,000 and no
Yeah.
possess.
Anyway, I don't have no income, no nothing. I show up to court as a proven fact I have proper, you know what I mean, education to go to
You
court.
have no what?
I don't have no money to bond out, nothing.
Okay, well, I need to give you a bond because, I mean, the law tells you as a convicted felon, you can't have a firearm. So,
Okay.
And
Yes,
you
ma'am.
got-
I know that. Yes, ma'am.
So-
I understand that. I was wondering if I can get an R&R.
no, I have an obligation to protect the community. And there's a reason why we have that law, no possession of firearms by a convicted felon.
But they didn't get the gun off of me. It was
Don't talk about that.
Okay,
Yeah,
you're right.
yeah.
All right. You're
Don't-
right. But
So,
anyways, yes,
And
ma'am. I
respectfully-
understand, ma'am. You're right.
But he shows up for court, he's proven a propensity for that.
yes.
And I got it. My record is short as hell. I just seen a nigga with four. I mean, a person with four. I'm sorry. My words. I'm sorry. I just seen a dude with like 3 pages. I got two lines. I don't do this type of stuff. You know what I mean?
Right.
That's all I'm saying. You know what I mean?
I
I
get it.
come to court. Like,
But
it's no problem. I
see
understand
you
what the
come-
law
well, no,
says.
you got 2 prior failure to appear.
Yeah, and that was in another court. I was in another jail. That's why I had a failure to appear. But that don't matter.
All right.
Your
Doesn't
bond is
matter.
going to be 15,000.
Yes, no problem.
That is the
Okay, thank
standard,
you, ma'am.
So, your next court date though is August 13th at 8
Okay,
a.m.
thank you.
I apologize. I missed that one piece.
Yeah, I started to. No firearms, ammunition, or weapons. So,
JLM.
Mr. Gale, don't possess any firearms, ammunition, or weapons.
Ma'am.
Don't possess any firearms, ammunition, or weapons.
You right, ma'am.
Okay.
Yes, ma'am.
All right,
I'm not
thank you.
arguing that.
Poor guy. I feel bad because he's right. I see all these people come up in the court and they got a long list, and they get PR bond, and he didn't, and I don't know why, and I don't know. I mean, I know there was a gun because he said it. He said it right there, but I feel really bad for him. JLM, happy birthday. Everybody's seeing this. Please leave a happy birthday comment. Please, please, please. I'm begging you. I just want JLM to wake up tomorrow or later today and hop into the comments and see happy birthday, happy birthday, happy birthday. It makes him feel good. It really, really does. So it will only take you 1 second just to say happy birthday, or just HB. I almost said HP, Harry Potter. I'm so used to it. I got stuck. Okay. That's Florida. You know how Florida is. I don't know what's going on with my poor dog tonight, but if you hear anything, she's fine. She's fine. All right. Now we're going to go to a case where the 2-year-old saves the day. Yeah, no, they don't. Okay, I have issues with this one, but that's fine. It's a 2-year-old to save the day. I think we're in California here.
Um, we'll get on the record. The protocol, the matter of the people's state of California versus.
Anybody know what candy that is? If you can figure out what candy that is. I I mean, like the right half of it kind of looks like Starburst, but the left half of it sort of looks like not sweet tarts. What are those little oh gosh, what are they called where you they're wrapped forget it. I don't remember what they're called. Not sweet tarts. Are they sweet tarts? Sweet tarts. No. Tell me what it is.
Christopher Emmanuel LaFranc, case number CR 24009-184. Mr. LaFranc is present with his attorney, Mr. Bowler. Ms. Palazuelo is present on behalf of the people. Matters on to date for arraignment. And Mr. Bowler, did you have the opportunity to review these complaints?
Yes, Your Honor. As well as my client does have a copy. The name and date of birth are correct. And I waive formal reading, waive further advisement of statutory and constitutional rights. Enter not guilty pleas to all counts, deny any and all priors and enhancements. Make an oral motion for continuing discovery and ask to be heard concerning bail.
All right.
I don't know why it is that I either get the prosecutor that sounds great and the defense attorney sounds awful or vice versa, but I can never get a court where both of them we can hear great.
All right. And in terms of the bail request and the bail hearing, what did you want to state?
I'm very sorry, but hear you, Judge?
You wanted to make an argument regarding bail. Are you asking for an OR request?
For him, yes, I am. My client is a veteran of the United States Navy, 8 years. He as well has 2 discharges. He has an honorable discharge.
Thank you for your service.
This incident stems from a long relationship, approximately 4 years. With his history of having an honorable discharge from the United States Navy, and me having good contact information from the client, I don't think he represents any type of threat to safety. Under Humphreys, we do have to have a clear and convincing evidence of threat to public safety. My client would not be alone, the alleged victim in this case. He does have other places in family that he can stay with that have nothing to do with the alleged victim in this case. His financial situation has changed just recently. He was working. However, with the closure of the Amazon facility, I believe in Turlock, I think maybe even Teague, I think it's at. He was recently laid off from work where he had been making approximately $3,000 a paycheck with 2 in a month, which means probably takes him 55 to 60 a month. However, he's not working. And that was several months ago when he was laid off. I would ask that people use on his own part.
Right. What's the people's position?
The people oppose, Mr. LaFranc poses a great danger to the victim and his own children. According to the police report, Mr. LaFranc has an alcohol problem. And the evening of the incident, the person he's in a relationship with, she's currently pregnant and they have a 2-year-old in common. She went to check on him to make sure that he's okay as he continued to drink. He was sitting in the car. She took his keys as he was intoxicated. He followed her back into the house. He pushed her down, laid on top of her, preventing her from getting up. She's pregnant, which posed a danger to the unborn child. She struggled to get up. He went let her up. The 2-year-old child had to intervene, and the child climbed on top of Mr. LaFranc, trying to prevent his mother from being strangled. Unfortunately, the child was very small, so he wasn't able to do that. He even the child even ended up getting a broom to try to hit Mr. LaFranc, so he would stop strangling his mother. We didn't charge a 273A, but I sure will at the next hearing. The victim lost consciousness. Obviously, losing consciousness while pregnant is a danger to not only the victim, but also the unborn child. And she also urinated based on the strangulation. She said that she was really scared. And this is not the first incident between you of domestic violence, and that his behavior is escalating. She told one of her children, if there's another child involved, to get her phone, and she was able to call her mom, and law enforcement did arrive. When law enforcement arrived, Mr. Frank, based on his charges of a PC 69. Yes, so he refused to get in the car. They had to place him in a wrap device. He was really belligerent with law enforcement to the point that he was telling them that he was going to kill their families. And then if he told the officer, if y'all lock me up and when this shit is over, I'll have the freedom to kill all of your families. And so there was some substantial struggle between law enforcement, and there had to be, seems like a good half dozen officers to actually get him into the vehicle. So there's some serious concerns. We have a pregnant victim, which is a huge risk for lethality factor for domestic violence. We have a young child who was involved in this domestic violence, and we have someone with, it seems like, a substance abuse issue. So the people will be asking for bail to be set at schedule. And I don't believe a CPO is really going to prevent Mr. LaFranc from harming the victim further.
All right. Anything else, Mr. Bowler?
Well, I may, we're talking about a domestic situation. Not when the plan is going out and getting fights with members of the public. Please not intimately. That sound like to me just based on the recitation, maybe you're the first one myself. So then arguing that he needs to be the first one approach of him instead of as a bit of false standards, something like the argument needs. So it could be a situation of time where it's at least a first. Nonetheless, if the court is unwilling to release him on his OR, which I do think he should be released in his OR, especially considering his career in the military, and that he will no longer be around the victim, at least for the time being. Bail does have to at least be set up at the court of it. My client currently cannot afford hardly any bail at all because he was laid off and is living off of the savings that he's working. So the bail must be set in that that's an affordable bail from the client. There's also other court conditions that can secure his appearance. If the court and the people are worried about alcohol, they can make 8 payments, 2 a week. I wouldn't suggest 1 would be enough in this circumstance. Probably 2 would be more reasonable, at least a week. I'm sure my client would be willing to go to 2 days a week. As well, if there's any issue with securing court appearance, more than one status hearings. Unfortunately, from what I understand, this county doesn't do electronic monitoring without my client paying for it himself. Like, for instance, San Diego, San Diego, well, I believe even Fresno is the biggest one. So there are other conditions that can secure its appearance. And of course, bail doesn't need to be set in measure. Okay. Although I did not send in financial declaration, I would look at court accepts no representation of working at things. Although he was not hourly, he was salary.
Okay. He's currently unemployed and does not have a job to return to, as he was laid off. Okay. Right. Well, the court accepts for the purposes of this hearing that Mr. LaFranc is unable to afford bail at essentially any amount that is set by the court as he is currently unemployed. The court has considered the arguments from both sides and reviewed the complaint. What concerns the court is that the alleged victim, Miss Melissa Ruger, is currently pregnant with his child, and they also share a small child in common. And this incident occurred in front of the small child, given the nature of the charges and the seriousness of the fact that this incident occurred in front of a small child. I understand that Mr. LaFranc doesn't have a significant prior criminal record, but the court has concerns about the safety of the victim, especially given the fact that she was pregnant, and still, in spite of that, Mr. LaFranc engaged in this physical altercation with her, which continued to ensue even with law enforcement, and law enforcement was called out to the scene. So, based on the circumstances, the court, based on the individualized consideration of the relevant factors, I find by clear and convincing evidence that non-financial conditions of release or a lesser amount of bail in this particular case would reasonably protect the victim. And so I am going to set bail provisionally according to schedule, since it's been indicated he's unemployed and couldn't afford even a lesser amount of bail. I do find that count 1 and 2 would be 654 to one another. So I will set bail in the amount of $140,000, which would be according to schedule if counts 1 and 2 are 654, count 1 being $75,000, count 3 being $40,000, and count 4 being $25,000.
Yeah, just 1 second before we quit. Your Honor, if I could say for the record, my client is telling me he can afford maybe a cash bail between $200 and $500. I always pitch to the court that if we can set a bail that's in the amount that client can afford, especially an amount that he can pay himself without going to court, my client can pay themselves without going to a bail bondsman, that would secure their court appearance even more likely than getting a bail bond, because they'll get that money back as opposed to a bail bondsman where they're just losing money.
All right, but you're indicating he could only afford cash bail amount of around $250.
$200 to $500.
Okay. All right. Well, at this point, I am going to set bail according to the schedule at $140,000, and
And we just may have the normal course of dates.
right. That makes usually set it within 4 days. Monday. All right, then I'm gonna set the matter for early case management on July 29th at 8:30 in Department 7. Initial time is not waived for the time being. And, Mr. Frank will be demanded on the bail amount that's
We need a criminal protective order.
oh yeah, the people did provide a criminal protective order. So Mr. LaFranc, before you leave court today, you will receive a copy of this criminal protective order, which is for the protection of Melissa Ruger. As a result of this criminal protective order, you must not do any of the following things. You must not attempt to or actually prevent or dissuade any victim or witness from attending a hearing, testifying, or making a report to any law enforcement agency or person. In addition, you're not to do any of the following things to Melissa Ruger. You're not to hit, fall, stalk, harass, strike, threaten, molest, destroy the personal property of or real property of, or disturb the peace or keep under surveillance. You're not to annoy her by phone or other electronic means or block her movements. In addition, you shall not exercise any coercive control over her that would prevent her from exercising her free will. In addition, you must not contact her either directly or indirectly through third parties, by mail, telephone, email, or other electronic means. You're directed to stay 100 yards away from her home, her person, her job, and her vehicle. As a result of this order, she will be allowed to record any unlawful communications you direct towards her. I will advise you that violation of this criminal protective order could subject you to contempt of court and or criminal prosecution by the district attorney's office. And also, as a result of this criminal protective order, you will be prohibited from owning or possessing any firearms, ammunition, ammunition feeding devices, or body armor. I am going to swear your client in, Mr. Bowler. So could you please stand, raise your right hand to the best of your ability, Mr. LaFranc? All right. All right, Mr. LaFranc, do you have in your possession or control any firearms, ammunition, ammunition feeding devices, or body armor? Let the record reflect that Mr. LaFranc has been sworn in and testified he does not possess any of the said items. All right, your next court date will be next Monday at 8:30 in Department 7. And that'll be the order. Bill set at $140,000.
Your Honor, if I just for the record, I'd like to just object to the service of the CPO. I'm not sure the service is legitimate.
For the CPO?
Yeah, correct.
You don't receive the service.
He's compelled to be in court today. That's against the CCP.
I will have an investigator. It's never been an issue. And if he is going to call the victim, I surely will be listening to the calls. It is never had such an interaction.
All right, well, he is going to be given a copy of this order today in court. So he is being served in court with the copy of this order. And your objection is noted, Mr. Bowles.
So at first, when I first saw that, I was like, come on, I had 2-year-olds. Like they wouldn't be able to, they wouldn't stop it. They wouldn't grab a broom. But now I'm thinking about it more. They would if they're used to it. Like if they're used to this happening, if it's normal for them, then they would run and grab a broom. They would try to stop it. If this was the first time, no, they just wouldn't. But this makes me think that this is a normal thing for that 2-year-old to see. And wow. So I think this next one, it's the same type of thing today, guys. But I think this next one might have a bingo square. I think I heard what I heard, but I'm not sure. We are going to see. I just like this judge. He talks to them a lot. He talks about the law with the attorneys a lot, which is nice. So this is more nerdy than funny, but I like this judge.
There, present person as his attorney, Mr. Franklin, today's time for sentencing and providing Mr. Franklin with a notice and copy of the defendant's right to court review. Okay, Mr. Franklin, have you otherwise had an adequate opportunity to review the pre-sentence report and the sentencing information with your client?
I have, Your Honor.
Additions, corrections, or deletions?
We do have a challenge. So OB-19. So OB-19 is language. It has to do with the
Interfering,
with security
of justice.
penal institution. So here it's scored as 10 points. The offender otherwise interfered with or attempted to interfere with the administration of justice. I don't see that as adequately scored at 10 points. He wasn't charged, I don't believe, with interfering with electronic communication device. When we look at the facts that are in the PSI, and we're not disputing those, then we have Haley trying to get her phone. It became physical. Doesn't even say what we're getting the phone for. So maybe we could score that if we have more information, but I think as it is, there's enough information to score that.
All right, well, let's find out what this finds.
Well, first of all, he was initially charged with the interference that was dismissed in her plea agreement. And as it states in the description of the offense, they were arguing the victim grabbed her phone and was attempting to call her mother for help. And the defendant took the phone and threw it. Police were notified. Eventually, the call did go through, and police were notified because that mother that the victim was attempting to call contacted police and let them know.
All right, Mr. Butler, anything else? Yes, Your Honor, I would just like to add to that the allegation of the defendant took the cell phone away from Haley's case that occurred after this alleged headbutt occurred. So she had reasonable motivation to make a phone call about that situation, and the defendant prevented her from doing that. And I think that's where it falls.
Misconduct. Thank you so much. Yeah, this is a nerdy case. We're going to hear law a little bit.
So I thought that first part was why this was scored. Frankly, the sentence in the PSI, the defendant reportedly took the phone away from Haley and tried smashing it. That clearly with the definition of 19 of interfered with or attempted to interfere with the administration of justice. But the PSI goes on to state, as Mr. Franklin has pointed out, that she then tried to get her cell phone to call her mother for help, and the defendant took the phone from her, throwing it against the refrigerator. They continued trying to get the phone, and it became physical. And then the part that was referenced earlier about she thought the defendant answered the phone by accident, but they continued fighting over it. But the defendant ended up going outside. She then shuts herself in the bathroom and spoke with her. Also note in some places, and that's at the beginning of the description, the mother called because she saw on a FaceTime call that he was physically assaulting her. So I don't think there's any lack of supporting evidence in the description of the narrative here. The defendant clearly interfered with the administration of justice or clearly attempted to interfere with her using that phone call for help, i.e. the administration of justice. So respectfully, I'll decline to recommend scoring at 19. Anything else? No. Okay, then Mr. Butler, anything on behalf of people or
I also have a challenge to the defense for scoring. And I'd like to look at OB7 regarding aggravated physical abuse, and that's either 50 points or 0 points. 50 points, the victim was treated with sadism, torture, excessive brutality, similar egregious conduct designed to substantially increase fear and So in this case, it's not laid out in PSI, but it is in the original police report, specifically page 7 of 9.
Thank you, Fozzie.
But it relates to the incident
I'm trying to do it without her here. I'm trying.
that we just discussed here with Jennifer Ronan that calling to report the incident that she had witnessed when that FaceTime call was answered. Not only did she witness things, but when she was with her eyes, but she also heard statements that had been made, and she told the police what those statements were, and she's quoted as saying that she heard the defendant yell as he's attacking Haley, quote, "Nobody can save you," quote, "They're too far away, I can do whatever I want to you," and then quote, "If they come, I have a gun and I'll shoot them if they come into my house." So those three statements were heard by the victim's mother, who is in court today, as well as another person closely related to her husband. Okay. And so with that, I think that those statements go above and beyond the actions needed to complete the crime that he was being sentenced for and being charged for, and that therefore does increase designed specifically to increase the fear and anxiety of the victim, and that 50 points ought to be scored for that.
Mr. Franklin.
What's difficult about this case is I've seen the body cam, I've listened to the descriptions that happened from the complaining witness the day of, so much closer in time when the memory is better. And when we look at the description of events, almost mirrors in the police report. And what do we have? I threw a plate, I tossed a plate at him, and I think maybe it hit him. No, she says at a different point when it's on the body cam that she threw a plate and hit him in the side. And I don't think she tossed it. She threw it, she knew what she was doing. She started this encounter, okay? And it comes into this scuffle they get into. Should my client have walked away and not be here facing a felony? Yes, but she instigated that, and then her description of how this phone got turned on, they were separated from their phone, they're in the bedroom, the phone's in the kitchen, suddenly it's recording on FaceTime. To me, that sounds like somebody's trying to do a gotcha. They're trying to amp my client up, get him to react the way they know he's going to react. He does, they get him on video, here he is being convicted of a felony. He shouldn't have did what he did, but I don't think when you provoke someone and you know you're provoking that person, I don't think you get the benefit of OB7.
All right, so the 50 points can be scored if the victim was treated with sadism, torture, excessive brutality, and then the argument here by the people is conduct designed to substantially increase the fear and anxiety the victim suffered during defense, and that chiefly centers around the argument that statements were made that nobody can help, nobody will get here in time, those types of statements. I don't recall any authority as it relates to OB7 in the scoring of OB7 for conduct that is simply oral in nature, statements made. I also would note that 50, authority that I do recall, requires a pretty substantial bar, hurdle, if you will, to get over. I don't know that statements that somebody can't help, that nobody will help, particularly when there is, if I read this narrative and maybe I don't understand the narrative because I don't have the advantage of the police report, there was an on again and off again struggle for the phone, clearly times that the victim was on the phone, including with mother, either before, during, or after, or a combination of all three, the incident. So it's hard for the court to imagine then that the statements by themselves, when there is this access and or struggle to the phone, I'm just not seeing that meets the criteria, the bar, if you will, for 50 points on OB7. So respectfully, I'm inclined to amend scoring on 7.
We're going to see the victim.
What's the case?
We're going to see the victim in just a second.
People being now 293 Bishop, 292, and 1111. In that case, the court found that the proper to score 50 points, and there was ample evidence that the defendant engaged in contact to increase fear. Specifically, the defendant ordered the victim to keep her eyes closed indicated that the other five accomplices knew who she was and had been watching her and made threats to her that they could find her again. And so with that, it was just the statements that led to.
But what was going on? What was the actual crime they were convicted of? Was this a home invasion? Was this a CSC in progress? What?
I don't know that,
It wasn't domestic violence. That was something completely different.
but that's not, I don't think that that's what's determined the crime, so long as it's a felony, that's all that matters. What matters is what the defendant said to make it even more fearful for the victim. In that case, the Court of Appeals did find that that was the case, going above and beyond that necessary to complete the crime. And in this case, it's the same. He's trying to make the victim feel hopeless, feel like he has all the control, and that would naturally increase the fear of anybody suffering an act like this. I'm going to read the victim impact statement and I'll be able to do it again. But obviously, this is a very violent crime occurring in front of two great children. These statements are being said. Among those children, I couldn't imagine what you would think, other than even more worried when he's saying these things.
All right. Now, I'm not familiar with that McDonald case, and I certainly would not rely on it without knowing more about the facts and then these statements made, how they are in conjunction to what was going on. So I just got to say right now, I don't know what's going on in the front row there, but you're making a lot of noise. I've tried to ignore all that I'm going to ignore, because if you're going to be in the courtroom, you're welcome to be in the courtroom, but you have to comply with the decorum of the courtroom, which means not being loud enough that you're distracting the attorneys in the court. And that's certainly what's going on. So that'll be the one warning. And otherwise, if you can't abide by the decorum of the court rule, then you can go now, and that'll be the end of it. If you want to stay, you're welcome to stay, but you got to do it in the manner that is appropriate. All right. So I would not rely on it without knowing the facts of what was going into the crime, what the crime was, and then how that relates to the statements. In this descriptive of the narrative, it's clear to me that there is a back and forth as it relates to the phone. There's a back and forth between the parties as it relates to this assault that was ongoing. And I just don't see the 50 points. Again, I understand the authority is a pretty high bar. And I don't see it here. So respectfully, I'm declining to amend that. So Mr. Butler, anything else on scoring?
No, that was great.
Okay. Then with that, Mr. Frank, I'll go back to you. You believe we have accurate information on which case setting?
I do.
All right, so now back to you, Mr. Butler. Do you have anything on behalf of the victim or the people?
Yes, Your Honor, I do. The victim in this case, I really would like to address the court.
All right, so Mr. Frank, if you client would have a seat, and then Bailey, you come on up to the podium, and when you get there, state your full name, spell your last name for the record.
Vampires.
My name is Haley Ronan. I'm the victim of this case.
Can you spell your last name just so we have it?
Ronan.
All right, go ahead.
At this point, I'm just going to be brief. So, since February 25th, I had never feared going outside or going to bed or closing my eyes. I never thought that he would hurt me the way that he did. I am not taking medication for my PTSD, and I have to take sleeping pills because I can't sleep because I'm too afraid to close my eyes. I look over my shoulder and I panic because I'm afraid I'm going to turn around and he's going to be there. I will always appreciate that he gave us my two beautiful children. They're doing great. So great. But if this, I need to know. I would like him to have supervised visits with the kids, just so I know that they're safe. And I do not feel safe being able to meet him by myself. I need supervised visits to do anything like that. he brought a lot of damage on me. And even showing pictures of him to my kids, my son will smack me in the face, or he'll hit me, or he'll try and hurt his sister. I just want you to know that I thought I was supposed to spend the rest of my life with this man, and I thought I could trust him. I never thought he would do that to me. It scares me. That's all I can say. But I just want him to realize that nobody ever deserves to be on their last breath. Me thinking that I'm going to lose my children or my wife. That's all I have to say.
All right, Mr. Butler, do you have anything else on behalf of the people?
Yes, thank you, Your Honor. There was interviewed in this case, and he did speak to the police. He referenced the fact that he has multiple personalities, and then he referenced his quote, demon personality that came out. That's what we're apparently responsible for.
And there we have it. It wasn't him. It was a different personality. And we do not have that for our bingo cards yet. Multiple personality disorder made him do this.
Again, it's not in the PSI. What's also not in the PSI is any indication of any mental health issues. So I'm not really sure what's going on with the defendant, if this is drug induced, if he does have mental health issues, if what the case is. But to have a situation like this, when there's no allegation of drugs, no prior criminal history, and then to have a violent offense like this happen to the mother of his children, both of whom were in the home at the time, very young children, is very concerning behavior. It's unique behavior. It's just stuff that you don't see very often without something else going on as well. What I'm also concerned with is the guidelines. It's shocking to me that assault strangulation is going to be a 0 to 11 guideline range, but that's because of its lack of prior record variables, really. Despite the fact that this is Class B felony. The agreement is for a pillory sentence in the guidelines, so that's 0 to 11. The recommendation in this case is to serve 4 days jail, 4 days served. That's the recommendation from MDOC, along with probation of 2 years. I think because of the violent nature of this offense, as well as the his concern about the mental health of the defendant, statements made to police, the lack of drugs being involved in this state mental health offense, I think this should be a longer term supervision. And I would advocate for definitely a longer term jail. And I certainly would not advocate for any modification to the no contact order, despite it being saying that she wants to have supervised visitation with children. I think he needs to get himself in a much better spot first and demonstrate that his court is not a threat while on probation before presenting him
Mr. Franklin.
Your Honor, as I saw earlier, dealing with the Attorney General, I like when I work with the Attorney General. The Attorney General has policies. And I can reasonably look at my client and say, well, you're charged with this case, this particular crime, and you can pretty much expect this, this, and this, because that elected official ran on a platform, and here's the policies. I don't agree with all the policies, but they do have policies. I have no standard of advice typically to give my clients prior to getting an offer in this county. Even with driving on a suspended license, I don't know if we're going to be able to get their license and get a civil infraction. We're going to do jail. We're going to do this. I don't know. A first offender, no criminal history, otherwise eligible for HIDA. Generally, this court said, if eligible, the court grants HIDA. It's not part of the offer. It's very frustrating in this case. Everywhere else I've been, a first-time offender, they get the keys to the kingdom, as this court has said many times, in their possession.
Keys to the court back. Okay. All right. 1 year, exactly.
It's a carrot, right? It's a carrot at the end of probation for my client to go after. But instead, we went right for the stick. But if you're not successful, prison. For a first-time offender. And so I asked, we negotiated long and hard on this case. Why no HIDA? There was drugs involved. It's in the police report that their method of stress detox and relaxation was to go in the closet and hit the dab ring. More on that in a minute. Why? Because his conduct was so egregious. It is a strangulation case. He admitted he put his hands on the complaining witness's throat. He admitted he choked. A man should never do that. Not to anyone, especially not to the mother of his children. A man is a protector. But let's put this into context a little more. Unfortunately, as we all know, strangulation does happen on a spectrum. At the worst end, murder. That's not this case. At the other end of the spectrum, we have contact, pressure. Now, I saw the video. I don't remember seeing bruising. There may have been bruising. There may have been red marks. Okay. I'm not going to talk about that. There was some type of injury. I don't doubt that. I'm guessing if there had been significant injury, we would have heard about blood vessels rupturing and all of that the prosecution would talk about. But I don't recall watching the body-worn camera. The complaining witness never complains of pain. She did have complaints. In her initial statement to police and in the comments that she made on the body-worn camera, her first thought goes to, how am I going to pay for all this stuff? How am I going to provide money? You know, basically, how will I get through life without having to pay or pay these bills? A legitimate concern. I just find it strange that that is the first concern. Those thoughts were closer in time to the incident. And as time has passed, the statement that the court heard today has changed. There are layers, and the incident seems to be more egregious now than initially when it was reported. And I'm just saying that initially it seemed a piece of sand, but today a pearl is presented to the court. And I'm not being mean. I'm not victim shaming. I'm just pointing out that the testimony has changed a little bit over time. And my client has to be this demon or this devil. And that's how we're justifying that he can't have HIDA. He has to be so bad that he can't have HIDA. It's possible that he could have HIDA and he'll be successful. I really think he would be successful. But what also this narrative does, it helps out if this is true, if he's really the worst person ever, he's so bad that his first time out, he can't have HIDA. You know, that's really good when we're going down to the front of the court and we're deciding things like custody and child support. But you have two young, unmarried individuals with children. One works, one doesn't. Understanding childcare, extremely expensive. That from personal experience. Now, these are not two people living their best life, okay? And certainly, they are not appreciating the two beautiful gifts from God that they have. They have two children there. And I don't know why that's not enough. But instead of seeing these blessings, they saw stress and chaos, and they chose to de-stress by doing marijuana. Let's go in the back closet and do some hits on the dab. Can do marijuana recreation on the weekend and then go back to life as normal on Monday. Most of the people I know that are involved in marijuana are daily users. And it's disgusting to me that the people have made it so easy for people to become addicted and have an avenue to supply that addiction. But that's the kind of people that the court is looking at here. These are people that are stuck using substances. And dabs are especially awful. They're a lot more potent. But it's common knowledge. Marijuana induces paranoia. We know that. The culture makes fun of people for smoking marijuana and being paranoid. Okay, which probably explains some of the fear that the complaining witness talked about. Okay, if they're doing the marijuana and they're paranoid, it heightens things. But these two were doing the marijuana because they wanted to feel something. And this is disturbing because you got a couple of beautiful children in the house that neither feels enough satisfaction from. So they're resulting to getting high in the closet because the kids aren't enough. These are two people in a dark place. It's a dark place. So rather than see the situation for what it is, my client's being framed as the devil. And this is dangerous thinking. And it's not productive for either party, my client or the complaining witness. If my client is
Yes, what she's doing is dangerous.
the devil, then Ms. Ronan doesn't have to take responsibility for her actions. She misses a growth opportunity. It takes a lot of strength to look at your partner in the face and say, honey, this isn't working for me. We're splitting up. We're not going to be in a relationship anymore.
She misses a growth.
It's a lot easier to blame someone else for your life not going the way you want it to be. And branding my client as the devil, that's an is statement. And that's why it's so awful for him. This is what he be. It's a state of being. And we know from the current culture, identity is a very powerful thing. More terrifying, however, is an identity that is imposed by the community and you're denied hideout, which is eligible. So the community says he's a devil. He's not good enough to get hideout. What kind of mindset is he going to walk around with for the rest of his life? He's a young man. His reward for, behaving himself through those years of compulsory hideout, where I could ask the court to give it to him over the objection of the prosecutor, he behaved himself, and his reward is, well, you behave yourself so you don't get hideout. Well, he has to be a devil to justify this offer. And there was no way this was ever going to go to trial. He admitted it. He took responsibility. So,
What do you been worse off in trial? He was charged, didn't he?
he pled to the most severe charge.
And the DV. What would have done the repercussions for trial?
Took responsibility for the crime. I mean, you can't get hired with a no contest plea. You have to say, I did it because the state of Michigan wants young people to admit what they did wrong.
We can't get it because Mr. Fleischer.
I know.
It's not too old. Has to be before your 24th birthday. 24.
No, they amended the statute. It's up to 26 now.
So, refresh my recollection, the amendment then still requires prosecutor approval from 21 to 26 something.
It does.
Yeah. All right.
The situation here, you got Ms. Ronan, she throws a plate at my client. He headbutts her, and then she politely asks him to move out of his way. The testimony from her perspective is so bubble wrapped, it's hard to understand what she did. She's trying to insulate herself, and rightly so. My client went to the police. He said, this is what I did. And then he downgraded what she did. He said, no, she didn't throw a plate. He was trying to protect her. It's not the case that he just randomly started choking her. They had a dysfunctional relationship. He shouldn't have done what he did. He should have left the house. But my client has all the marks of a person who's going to complete probation successfully. I wish it was with HIDA. I wish we had a standard in this county where I could look at my client if it's a first offense and it's not the crime of the century, which this is not, and say, we can try to go for HIDA. Don't screw up again. Go on, have a good life. I think anger management, counseling, relationship classes, these are all things that he's going to take and use and become a better person. It's just unfortunate that the goal here is to saddle young HIDA eligible men with felony convictions, which is almost a guarantee that a child, in this case children, they're going to lose their father in their life.
Thank you, Donald.
So
And
I would
no,
ask the court to
you never
give my
have.
client a chance, put him on probation, and let him have the extra difficulty of life of navigating it without a high school diploma and a felony conviction.
All right, Mr. Thayer, anything you want to say before the court imposes sentence?
I would just like to apologize to Haley if that's possible, sir.
You say whatever you'd like.
I'm truly sorry for everything I did, all the pain and suffering.
All right.
Yeah, but who's apologizing? Which personality? I would like all of them to apologize, and still it wouldn't matter.
So interesting case. I will say this, when I read this, it's accurate. I just don't see what happened here in the big picture. We handle a lot of assault with intent to grave bodily harm, less than murder, and here's the key, or by strangulation. So it's a great big 10-year felony that didn't used to be applicable to very many cases until they did that, or by strangulation. And Mr. Franklin is kind of honed in on that. That becomes a sword as it relates to generally men and domestic violence situations, and probably often is warranted. But again, going back to the big picture as it relates to what happened here, certainly very scary for Haley. But when I compare it to other cases of GBH or by strangulation, it's relatively benign compared to much of what we see. I also share the, I guess, complaints over the years about who gets off and what and why. This case not being much different. So apparently the office plea is charged, meaning not only are you going to eat the felony, you're going to plead to the misdemeanor too. Now, it would make sense to plead to the misdemeanor if you got YTA on count one, but I don't get it. And it's not the court's bailiwick anymore, other than I call out when I see it generally. Sometimes I just give up, I get tired of it. But it does not seem very fair to both sides when you don't even have that opportunity. And I'm going to say that because Mr. Thayer, in spite of everything that happened here, stands before the court with no prior criminal history. And he's 25 years old. So that means he's made it through all those teen years, through all those early 20s, almost to the point where science and our Supreme Court now, and where we're going in the criminal justice system, would say your brain is almost fully developed. They'll tell you that doesn't happen until you're 26. And there's a steady march in today's world where it hasn't made it to assault with intent to great bodily harm by less than murder or by strangulation yet, but certainly it's made it in the context of murder. You could murder somebody and they would say, oh no, we can't give you life without parole to a 17-year-old. That's cruel and unusual punishment. Your brain's not fully developed. Our Supreme Court is taking up right now, if they haven't already, that's going to then be extended to 18-year-olds. And then I can guess where that goes next. Eventually, at some point, that'll make it all the way out, probably until 26, because your brain doesn't develop until you're 26. And that's sort of the philosophy of where we're going in the criminal justice world. So I don't understand when somebody's eligible why they don't get, for a lesser charge, that same opportunity. Now, the flip side of that, if you've been sitting in here all morning, at some point you'll probably be able to come back and ask to have this set aside. And again, with that swing left, even if the court thinks that's a bad idea at the time, and even if Haley comes in and says it's a bad idea, the new case seems to say, well, too bad, circuit court, too bad, trial judges. The Supreme Court has determined that in the public welfare doesn't mean anything about what a victim thinks. It just means you're going to grant. I don't know why they don't make it automatic in light of what's happening. I guess those are all bigger topics.
The person at the bottom left is actually a drug dealer. It's okay. She was dealing cocaine. No, sorry. She was dealing fentanyl, but it was an accident because she thought it was cocaine. That person is this person right here is a drug dealer.
They're sort of on point here, but really outside of the parameters of sentencing you, are interesting to think about as it relates to a case like this. I will say this, Mr. Thayer, Mr. Franklin has honed in on something that, again, is not in the report. So it seems that both sides have mentioned this. If there was this idea of drug use, meaning marijuana, dabs in particular, that is a dead end to nowhere. I share his frustration. We lose that argument about marijuana when we allowed all these states 15, 20 years ago now to put the word medical in front of marijuana. Because it's just not accurate 99.9% of the time. And while science will tell us that marijuana is not a gateway drug, I don't know that Mr. Butler, Mr. Franklin, or the court, or Ms. Bond, it's hard to identify somebody who has an addiction to a hard drug that didn't start with marijuana. There are those instances back in the Oxycontin days where somebody had a knee surgery, for instance, and they give them the Oxycontin and then they develop a severe addiction to opioids. But as far as meth, cocaine, a lot of the other hard drugs, it's hard to read a PSI where they don't start with marijuana. And the marijuana normally is preceded by alcohol. So I guess people smarter than I can show you the science behind why it's not true that it is a gateway drug, but it's certainly not what we see here. So that means that for you, I don't know if Haley's involved too or not, but for both of you, or certainly for you, you're the guys going to get probation. It's just a dead end of nowhere, and it's not going to help you be successful on supervision, be successful in relationships, or as a father. Just didn't. And I think the time and our experience here bears that out. Now, as it relates to supervision, when I prepare these, you're 25, you have no prior criminal history. I think that this report here and its recommendations are appropriate. And now that I've had the benefit of them listening to the arguments as it relates to an appropriate sentence, nothing has changed, at least from the court's perspective. I keep going back to the idea you don't have any criminal history. And if I could, I would give you delayed sentence. I would give you YTA. I'd give you any first offender status I could, because you would hold the keys to that. You should have that opportunity to not have a felony conviction. It clearly can impact your ability to earn a living. And that clearly then impacts your children and indirectly impacts Haley, right? The less productive you are, meaning ability to earn, the worse it is for those two kids, and in kind, the worse it is for Haley. Now, as it relates to that, you've got to be very careful here. It sounds like to me, based on what I'm hearing in the argument, certainly not contained in the PSI, that you two don't have a FOC case. That's something that's going to have to occur, right? You're not married, correct? So that's got to occur almost immediately so that there can be some sort of parameters in place as it relates to custody, parenting time, all those issues. Now, maybe you two can reach agreement on that, but the risk with that is things might be great tomorrow, and then 2 months from now, you're in love with somebody else, or she's in love with somebody else, and then one of you is upset about that, and things go south. It's just sometimes easier to have the FOC spelling out in great detail how things are going to go for you two. Now, to the extent that the court much prefers parents to make that decision, if you can, and lots of parents can. Sometimes that just doesn't work out, and particularly if you got one of the parents on supervision, lots of things go sideways in that scenario for lots of different reasons, right? Sometimes this conviction will be used as a sword by the other. So there's just a lot of things that make it difficult. So one or both of you ought to be thinking about filing the appropriate motion.
It's sort of like a HIDA is sort of like a deferral for first offenders. Yeah, it's like diversion. So he would have to finish probation, blah blah blah. Charges get taken off his record, but because he strangled her, that doesn't work for him.
And getting that set in stone, so to speak, in writing. Mr. Thayer, I am going to follow this recommendation. It is appropriate. I'm going to place you on a period of supervision for 2 years. I'm not going to go over all the terms of your supervision. I'll highlight some of the ones that I think are most important. And we'll start with this, and we'll require that you complete domestic violence and battery intervention programming. And you'll follow all the recommendations of that as you go through it. I'm also going to require that you complete the COG program. I think that certainly can help you as it relates to decision making. That's a program that's designed to help illuminate you on how folks go about, how you go about making decisions, and how you might make better decisions in the future. I'm also going to require, now this is going to be very difficult because you're a parent, and it's going to be difficult for Haley too, but I am going to follow this recommendation and require there to be no contact, verbal, written, electronic, or physical with Haley Roman, either directly or through another person, and you can't even be within 500 feet of her school residence or place of employment. Now that makes it hard to be a dad. Again, we're going to need some orders, most likely from the FOC. That also means as it relates to visitation with your kids, you're going to have to somehow work through a third party, okay? That does not mean you cannot see your kids, and there would be nothing about this supervision that I would do that would prevent you from seeing your kids after the FOC has had those hearings to determine what appropriate custody and visitation and parenting time, all that stuff should look like, all right? Generally, it's always preferred that that's just 50-50, right? You have shared legal custody, shared physical custody, and equal parenting time. Mom, you can shake your head no, but that's the way that works, okay?
If he had HIDA, he would have been charged, and well, he would have been charged, but the charge would have been suspended until he did, probation or whatever that. And if he did it, if he completed it successfully, then everything would be dropped like it never happened. It's because he's only 25 and he's a first offender. So if you're young and you're a first offender, then you get this special thing where, oops, you made a mistake, but you were young and stupid. We're not going to punish you forever for that, which he should get because he qualifies. But there's a thing in there, strangulation. If you strangle someone, you don't get that.
This conviction does not mean he doesn't get to be a father. And to the contrary, you'll see lots of probate law that gets overturned all the time on termination of parental rights. That's just the way it's going today. The pendulum is swinging left. So we can shake our head no, but that's not what the appellate courts are saying. So that's the way that'll be viewed in the FOC, any FOC, and that's the way this court views it, because that's the current status of the law.
Can I say something?
No. So you can talk to Mr. Butler about it when you're done. However, that's going to be a problem for you, okay? So again, somebody's going to have to get over there and get some parameters put in place. Once you do that, the obvious option, I'm just speaking out loud for both sides here. There are apps that the FOC use, App Close, Parent Wizard, things like that. I will amend this once FOC order is in place to allow you to have contact with Haley through the app. What the app does is it tracks both parties' communication, one or the other. Basically, it's a texting app, all right? So it protects her, it protects you. All those communications get preserved, and then either side can then say to the FOC or the court, aha, it's Thayer that's the problem, or aha, it's Haley that's the problem, or maybe it's neither one that has a problem. Maybe you just need to figure out a way to communicate better. It also has calendars that both sides can put in, okay, I don't know your kid's name, Johnny and Mary have cheerleading practice on these dates, and at some point, the first 3 days, it's her days, and the next days, basically so you can keep track of things together, what that looks like as far as medical appointments, school activities, all of those things. Those are, unfortunate realities for the two of you coming down the pipe here. Okay. But right now, no contact with it. Obviously, while you're on supervision, you can't engage in any assault or threatening or violent behavior. I'm going to require that you maintain employment of at least 30 hours a week or a combination of the employment and your supervision obligations. I'm also going to require a curfew. So you have to be in your approved residence between the hours of 10 p.m. and 6 a.m. unless you first have permission to be outside your residence during those approved hours. If you have employment during those hours, you need to clear your probation first, right? Nobody's going to prevent you from reporting.
Yep.
So as it relates to fines, costs, and other monetary obligations, the court is required by statute to impose $118 in state costs, and that's broken down $68 on the felony, $50 on that domestic violence misdemeanor. You also have to pay a $60 DNA testing fee. There'll be attorney fees in the amount of $400, court costs of $550. While you're being supervised over these 2 years, your supervision fees are going to be $30 per month. I'm also required by statute to impose a $130 crime victims assessment. And then finally, sir, I'm going to file this recommendation. It is appropriate. You're going to be sentenced to 4 days in the Miami County Jail credit for 4 that you have previously served. All right. You do have a right to seek appellate review of your sentence. If you'd like to do that, you have 21 days from today's date to make that request. If you want a court-appointed attorney to assist you, you have 42 days. So I'm going to place this in the file. Are you prepared to make any payment on those fines and costs today? Okay. Did you post a bond?
My grandpa gave 1,000 and I've been paying on the other 1,000 as we've been going through this.
So to the extent a bond needs to be returned, some of that can be applied to your fines and costs. Okay. Grandpa here with you?
Yes, please.
Okay. Any of that going to be applied to the fines and costs? How much? Yes. Oh, bail bondsman. So that's not going to help you. All right. So what do you think you can pay a month?
Pay probably 150 a month.
150. Are you working?
Yes.
Okay. Is that full time?
Yes.
All right. So why don't we start at 150? You can always pay more if you have more.
Right.
If you are not going to be able to make a payment for some reason, don't just ignore it. Talk to probation, talk to collections, and we'll see what we can do to accommodate that if possible. All right. So we'll set you up on a payment plan. I need you to check in at Circuit Court Probation. That's at 309 West Adams. You cannot leave town without first checking in at 309 West Adams. Okay, you know where that's at? All right. So what I want to do then also is caution, that's going to complete the matter. So I'm going to ask for you to hang on a minute with your attorney. I'm going to ask for these folks to exit. I got a security guy here. We need to do that in an appropriate manner. Mr. Butler.
Yeah, just before we go on the record in this case, Karen, I was informed by another children there is an FOC case in Genesee County. It's already.
Nobody can hear
Perfect.
me.
So then both of you are free. You're going to be free to file whatever motions you think are appropriate.
This is my contact.
Thank you.
All right. So it's unfortunate that's not in Ione County, but in general, I think if you bring up to the FOC that this court is going to amend your bond order to allow contact through one of those apps, they should generally do that. This conviction should not prohibit you from being a parent to your child. Do you have any idea how it ended up in Genesee County?
I was there.
Okay, so what happened to our venue here?
She must have moved there.
Yeah.
She moved
After this incident?
when I went to jail. Her mom and her boyfriend came and picked her up and moved out there.
So filed it in the most convenient location. You're all set.
There's no presence required.
Okay. You should be able to hear me good now. If I bump it up, people in comments say I literally blow out their ears. So if I bump it up any higher. But I will if you need me to. Just tell me. I yodel. I am not yodeling. I mean, I want to. It's right here. Okay, I have a camera. I have a microphone. I'm almost like a streamer. Almost. Let's go to Fleischer, guys. This is going to be, what, the 4th or 5th time you've seen this today, Legal? Poor guy. Guys, you guys are going to have to spice this up a bit because Legal has seen this a lot of times today. Speak in your outside voice. Speaking of, I have to go get my dog from outside before she runs away again.
All right, we got you.
Awesome.
Hi,
So,
Judge.
good morning, Your Honor. I'm present on Miss Melissa Vasquez.
Judge, it's not in arrangement, but the defendant is to be drug tested today.
Okay, let's send you for a drug test.
Yes, sir.
Tracy, you ready? All right, I'm gonna have you come with Tracy. You must come back right afterwards.
Yes,
You
sir.
understand?
Yes, sir.
Is this
Okay.
Garcia?
Yes, ma'am.
Oh, Judge, that's not who brought
This is-
up. This is Garcia in arraignment on page 9.
Wait,
Garcia Miguel.
what's your name?
Miguel Garcia.
Okay, that's like, it didn't,
Rock is talking about Vasquez
Yeah.
on page 26.
I'd still like to send her for a drug test too, though. Yeah, so take a seat from here in the juror box. We're gonna send you for a drug test right now.
Yesterday. That's what time it is. Yesterday.
All right, Judge,
Okay.
the next arraignment is page 18. Martinez, come on up.
Come up, ma'am.
Is that Jason or Josh?
What is your name, ma'am?
I think it's Jason.
Last name?
Jason. Yep, it's beer. No, Kelly, absolutely
See what
not.
page she's on?
What was your last name? Oh, Silas?
I don't have it either, Judge. I have a Martinez, but it's a male.
Page 18, Martinez.
What's the first
No,
name?
that's Ricardo Martinez Cardenas. That's not Ricardo Martinez Cardenas. Okay. But I don't even see her name on the docket regardless.
Page 19, Megan Martinez. We just said we're waiting on the count.
Got it.
Oh,
Okay.
No, it's okay. We're just figuring something out.
Yeah, we'll have to bring her up here.
Judge, we're going to need an interpreter for.
Ready, Luis? Please.
Ready, other Luis?
Yeah, ¿quién es abogado? Oh, that's right. Greg Payne. Okay. Sir, you are Ricardo Martinez Cardenas. Sir, you are charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You were facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present during any questions and interviews with the state of Texas. If you cannot afford a lawyer be appointed to represent you, sir.
Thank you, Rebecca. Thank
Judge,
you.
on July 14th,
Thank you.
2024, officer was at a complete stop at the traffic light when the defendant struck his marked patrol unit from behind. Upon contact with officer, the officer observed red bloodshot eyes, slurred speech, unsteady balance, and an odor of breath.
If you're gonna drink and drive and hit something, always make sure it's a police car. Always. Oops.
Alcohol from the breath. Standard field sobriety tests were conducted. HGN could not be observed because the defendant kept moving his head and could not follow instructions. The walk and turn was a 7 out of 8. The one leg stand was not administered for safety reasons. DIC 24 read, the defendant consented to breath, which resulted in a 0.239 and 0.241. The defendant admitted to consuming 2 to 3 20-ounce Bud Light beers.
Can you run his license to see if he has any prior DWIs, please, or run his history? Do you mind? With that kind of BAC. Mr. Martinez, tell me, are you a United States citizen? Do you have a Texas driver license?
Yes.
Do you have valid liability insurance in your name?
Yes.
It is eligible. Okay. I'm finding probable cause in your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of dope, I will put you in jail. Do you understand? I don't know if you are a resident. I don't know if your paperwork is good or not. It may not be. But I'm telling you that if you have any problems with your immigration paperwork and you go to jail and immigration finds you because they sweep it on a daily basis, they will put a detainer on you. You will be stuck in jail until this case is over with, which is about 9 months. Do you understand? Do not violate these conditions. Otherwise, I will put you in jail. My sole purpose is to protect Harris County in every single way. Do you understand? All right. You have a lawyer. Because you have a lawyer, I will waive your appearance. You do not have to waste your time coming to court, but you must stay in touch with Mr. Pena. He will tell you if and when you have to come back to court. If Mr. Pena tells me he can't get a hold of you because you're playing games and not responding to phone calls or text messages, I will issue a warrant for your arrest. For now, we will have you go to Victoria, sign a reset. After that, you will get the chase through your bond conditions. And after that, you're welcome to wait for your lawyer in the back.
You know what? This is actually the first time I've seen this. I only ever watch this for the first time with you guys. When I'm in there during his stream during the day, it's on mute. It's on mute because I'm doing something at another court beside me. And then like today, I was in Lone Wolf's channel when he played this. And again, it was on mute because I was doing something else. I'm in the chat and I'm talking, but I can't hear what's going on. But it works well because at some point this week, or was it last week, apparently there was a really sad story with a death. And I completely skipped it. I didn't play it on my channel at all because I saw in chat that it was just too sad. So you guys didn't get to see it. But if you want to, go back to his stream. She has a white shirt on. She's pregnant. She's at the very beginning of the stream, and then near the end, I think it was, well, I guess it had to be Monday. I don't think it was Friday. Is it really bad? Is my mic really low? Oh, if I bump it up. Oh, oh, oh. Oh, I can already hear the comments happening. Okay, that's as far as I'll that's as far as I'll go. Here we go. All right, interpretive dance time, but I'm going to turn the camera off for that.
Please, sir.
Good job. Nice. Thanks, Terry. Hi, Linda. Metal goals.
I don't know why you're looking back there, but there's nothing back there. Ma'am, are you Bria Edwards? Your case is 1,153 days old. You've missed court over and over and over. And your bond is now 7,503. Every time you miss court, we revoke the bond and double, if not triple it. And all you're doing is giving free money to bonding companies. You are putting their children through college. So you must have a lot of money to just continue to give bonding companies money. You're making it rain at bonding companies. That's what you're doing. Do you have a lawyer today, man? I'm going to appoint you someone. We figure out today what happens. Take a seat for me in the jury box, please. Do you mind, please? Thanks. Oh, where's Docket? Okay, how's Mr. Bonilla?
It's not Sonia.
He's okay.
Oh gosh, what's her name, guys?
You're hesitant.
Is it Sonia? No.
Is he high right now?
Yeah.
I'm sending him today. Mr. Bonilla, come up. Tracy, I'm sending one more person for rapid. Okay, Bonilla, yeah.
Sonia. Thank you, Fozzie. Legal.
Good morning, Mr. Bonilla. How are things with you? How are things?
Things are all right. I'm going to.
Aren't we all? We still work though. Still live life. Have you been working?
No, sir. I haven't done
Shh. Guys, keep it down. I can't hear a thing. You need to speak louder because I can't hear you.
So, 2 weeks ago, I'm trying to get some blessings.
Okay, stop saying like. Speak to me without using the word like.
I told her I'm going to combine with my whole family. I'm going to combine, and it feels like
I don't know what that means. No.
I can't see nothing. I'm blind. I'm blind. I'm like, and I've been trying to get my deed, but I don't have the money to do it.
So what have you been doing the last 2 weeks? Doing what? Sitting on your tuches and doing nothing? What do you do all day? Did we not order him to have a job, Sonia? First things first, I'm sending you for a drug test right now, and I want you to come back, and we'll talk about where we're going to go from here. But just because you don't have glasses, and I think that I'm hearing you right, you're telling me that you can't do anything because you don't have glasses. Is that, am I right?
I see street sunset. Like,
And you sit at home, do nothing to help your cause.
Well, I try and ask money, you know what I'm saying? I try and ask money.
Who? Do you have a fairy godmother that's going to give you money?
No.
Your mom works for money. She's not going to just give you money because she knows where that money's going to go, Mr. Bonilla. History tells us if she gives you money, where that money's going to go.
Sally Port, can you give him money?
If you want money, if you want the life.
Sure, I was going to ask you if I can be here because I heard y'all give up.
Mr. Bonilla, you have to work for it. No one is going to give you handouts. You're going to ask me for what?
For an ID.
You're going to ask me for an ID? Really?
I heard y'all give homeless IDs there. I mean, I might as well. It's worth a try.
That's not all he asks the judge for.
You go to the DMV for an ID, Mr. Bonilla. That's what you do. Let's do this. I want to see what, if anything, that you're on, because you've been sitting around doing nothing for 2 weeks. And when you sit around and do nothing, you become self-destructive.
Is that English? Gary?
I feel like I'm predicting my own death. I feel like I'm going to die anytime, any given day. You know, my death is soon. You know,
you have too much time on your hands. You need something to do, Mr. Bonilla. You sit on a couch, do nothing, and what happens? All you're doing is thinking. And then the thinking becomes worse. You start thinking bad thoughts.
It's Sophie.
You need
something
to occupy your time, and that's why you need a job. Even if it's working at Sunday or working at Subway, building sandwiches, it's something to do. Even if it's cutting lawns 8 hours a day, it's something to do to keep your mind occupied. You're not listening.
The cat paused it. I restarted right away, but I wasn't going to re-record
You're
everything.
thinking about what to say because you need something to occupy your time.
Cross stitch is
To
nice.
get your mind away from the nasty thoughts. Let's do this. First things first, I want to send you for a drug test. Come back and we'll go from there. And then we'll figure out where we're going to go because I want you to do something with your life, not just sit on the couch 12 hours a day until you go to bed or start running the streets again. This is unacceptable. I know that we have more conditions on him than this. Unacceptable. Let's do this. Can you please? All right. I want you to come back. Do you understand, Mr. Bonilla? Okay. All right.
John, are you near somewhere where you can go crabbing? Because crabs love old, nasty chicken. Just saying. You get some crabs. Hello.
The complaining witness is who?
Cross stitch.
Is it
It's
Mom?
fun.
It says here he will have no contact with Maria Loza. He's not supposed to have contact with her.
Go for it.
Shh.
Sorry.
Yeah.
Okay, that is the
That's the complaining witness in the theft case in Target.
What is it?
That's the complaining witness
Is it you?
theft case in Target. So
it's a target. Got it. Okay. All right. Yeah. We need to start doing something with him. Yeah, it's okay. Well, let's do the drug
Michigan,
test first, and then
I
we'll
think.
craft a plan.
Right, Lori? Michigan?
I'm gonna, depending on what happens with the test, I'm gonna reach out to the MAC to have them evaluated to see where we're gonna go from here.
She sure does.
And he's making a time served and a deferred offer with a TRAS to figure out if that may offer some sort of assistance. He did also mention to me wanting mental health help, but he's not very confident that it will work. He told me that he's been to Bentab and they released him shortly, even after he just spilled his guts. And he's not sure, today, and he's not feeling confident it's going to help him.
Okay, I'm gonna help him with the confidence. I'll help him. So, do you have anywhere else to go other stuff? Yeah, will you come back? Okay, thanks, honey. Hey, good morning. Yeah, for sure. Any priors or anything?
No.
Are they here today?
Yes.
You want to send them now since they're here? We can do a walkthrough now. Okay, let's do it. And then we'll sit you off a couple weeks. Yeah? Okay, like 2 to 3 weeks after that? Sure. Thanks, Justin. Miss Scott.
Good morning.
Good morning, ma'am.
But we've seen you,
ma'am,
Terry.
You're charged in here
We've
with
seen
assault
you.
of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present during questions and interviews with the state of Texas. If you cannot afford a lawyer we've wanted to represent you, ma'am. Okay.
Judge, just so it's easier for you to follow me, the first complainant is a 16-year-old who is the sister of the defendant. The second one is a 14-year-old who is the daughter of the defendant.
What?
There's 2 complainants. One of them is the sister of the defendant. One of them is
How is it that she has a sister that's 16 and also a daughter that's 14?
Judge.
We don't control family dynamics, Judge.
Okay. I mean, go ahead.
On July 15th, 2024, officers responded to a family disturbance at a hotel in Harris County, Texas. Officers met with 2 complainants who both had visible injuries from a physical altercation with the defendant. Officers observed the defendant had a strong odor of alcohol on the breath and person. The defendant was unable to walk a straight line and was stumbling. Complainant number 1, 16-year-old, is the defendant's sister. She stated that she observed the defendant consuming alcoholic beverages. She advised that complainant number 2, the defendant's daughter, told the defendant to stop consuming the alcoholic beverages and attempted to remove the alcoholic beverage from her hand. The defendant then, with an open palm, pushed complainant number 2 and then began striking complainant number 2 multiple times, then biting the right ear of complainant number 2. Complainant number 1 attempted to intervene where the defendant...
14-year-old, biting the ear of the 14-year-old?
No, Judge.
16-year-old.
Correct.
Okay.
Complainant number 1 attempted to intervene where the defendant began...
Oh, it went away. We got more. Hold on, I'm getting it back. We got not just a little bit more Texas than Michigan, but a ton more Texas than Michigan. But in your defense, Michigan, Texas is freaking huge. Huge.
Striking complainant number 2 multiple times, causing her pain and discomfort. Officers then spoke with complainant number 2, the 14-year-old, who is the daughter of the defendant. Complainant number 2 stated she observed the defendant consuming alcoholic beverages prior to going to work at Little Caesars. After the defendant returned from work, she continued having alcohol. She told the defendant to stop consuming alcohol and attempted to remove the alcohol from her hand. The defendant then, with an open palm, pushed her and began striking her multiple times and pinned her to the ground, then biting her right ear, causing her pain, discomfort, and to bleed. Officers observed that complainant number 2 had a bloody ear with blood on her forearm and right thigh from the injury, bleeding profusely. Both complainants want to pursue charges against the defendant.
Okay. So, Ms. Scott, I'm going to find that there's probable cause to go forward with your case. You know, there are some people, when they consume alcohol, they become very happy people, little bunnies jumping in the woods. And then there are some that turn into complete
2.1%.
Jekyll and Hyde type person. If you're one of those, no more alcohol. And I'm now making that a condition of your bond. Do you understand? I'm also ordering as a condition of your bond not to have any contact with the complaining witnesses in this case and not to be in possession of weapons.
Separate
The protective
times.
order has already been issued. The reason you're still in custody now is because you have a $5,000 bond on the felony case because of the alleged assault on the minor. That's why they charged it as a felony injury to a child. Are you planning on bonding out, man? Well, let's not talk about the case because you have the right to remain silent. I've got a bunch of DAs here and I don't want you to say something that hurts your case.
I won't be able to bond till next week.
Okay. If you do bond out, find another place to go.
I do.
You understand?
I stay with my uncle.
Okay. No alcohol from any source. Do you understand? Does she have any other priors? I don't.
No good.
Okay. Do you mind filing no contact and no weapons, please? So it outlives. Okay. All right, ma'am. So what we'll do now, I've given you a lawyer. It is your responsibility to stay in touch with her. She will tell you when you do get out, she will tell you when you have to come back to court. I'm going to tell you now, my sole purpose in life is to protect every person in Harris County. I don't care who they are to you. I don't care what their age is. You pick up a new case. You do anything to hurt any single person, I'm going to revoke this bond and I will make it so high you'll flip. Do you understand, man? Please, no more alcohol, no more dope. Okay? Okay, man. Yes, ma'am. Yes, ma'am. Don't send her down there. We need her to sign conditions. Trinidad. Yes, ma'am. Yeah. You have a plea, right? Are you ready? Okay. Megan Martinez, come up, ma'am. Ms. Martinez, you were charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. You guys have worked out an agreement where they're offering you 180 days in jail. It will be probated for 1 year. As part of the probation, you will do a DWI education class, a victim impact panel. You will do a TRAS, which is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill those conditions. Substance abuse treatment, no drugs, no alcohol. You must have a guardian interlock, 20 hours of community service, and a $100 donation to the Houston Food Bank. Is this how you understand the conditions? Understand when we mean no alcohol, we mean no alcohol from any source. Cakes, candies, foods, gums, tequila, lollipops, hair dye, we've heard it all. The other thing that I'm going to counsel you on is that this DWI is going to go on your record. You now have a lot of drug cases and now this DWI on your record. When you get pulled over, what do you think an officer is going to do to you? Right. Don't matter if you're drunk. Don't matter if you're high. Don't matter if you have any kind of smell on you. Your record in and of itself, they're going to try everything in their power to search you. Don't give them a reason to put you in custody. Yes, sir. Even if you have the faintest smell of alcohol, they're going to charge you with another DWI. So even after 30 years, you're done with this. You have a sip of alcohol. Don't get into a car because you're just going to come back. Do you understand? You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So once you accept this agreement, you can never change this or undo this. Because this is going as a conviction on your record, from now on, you will be facing a minimum of 30 days in jail if you ever pick up another DWI. Do you understand? All right, I will not suspend your license today. Your license will remain intact, but just be careful because I don't know what happened on your ALR case. Do you know if she lost her license because of that?
I believe she may have, because it was
Don't
bad.
just start driving. You may have a suspension due to an administrative license revocation. So if I were you, call DPS first before you start driving, because if you drive and you don't have a license, you're in violation of this probation.
I'm going to do a non-driving affidavit, Your Honor, so we can get it portable.
Okay, I'm okay with that. You know what?
Your Honor, and she works as fire watch in different places, right around the Houston area, a little bit north. There's random urinalysis. If she gets called, she's gonna have to come all the way back. She doesn't have it.
They put her in a region next to her house. She don't come back here.
Right.
So they'll put you, we've got different quadrants around the city. You will go to where a house or the place where you go check into every month. It's going to be a place near your house. Okay. You're not going to be coming back here. Jason, do you know how to run a license?
I don't think we have access to it.
Okay. Before you leave here, I'm going to have this. Pavel, yes. On Miss Megan Martinez, will you run her license, see if it's eligible or not, please, just so we know?
Thank you, Your Honor.
Okay, ma'am. How do you plead to the offense? I'll find you guilty. I will follow the agreement. Good luck to you.
Thank you, sir.
All right. Oh, wait a second. What do you do for a living?
For the industrial, like the chemical plants and stuff.
What kind of money do you make?
I work part-time, so roughly $20 an hour, depending on what, maybe, you know.
Okay, you can reduce your fees, please. I wanted to know, so as far as your fees, how to handle it, and we'll reduce your fees to the minimum. Okay. Okay. And thanks for that. She's eligible. Okay. So there's no ALR suspension?
I believe.
Or is it over already?
Should have that, yeah.
So
90 days.
ALR suspension was.
Because it's just not going to unsuspend itself. If there wasn't a suspension, you have to pay a reinstatement fee. So. It's weird.
There is a suspension. It begins May of this year, May 25th, and it's November 20th. I was saying, Judge.
So it is suspended.
Yes.
Okay. Don't drive. You can get an occupational, talk to Trinidad, and he can help you with that if you need it. But don't just start driving then.
Yes.
You're in violation of the probation if you do, okay? Okay, guys. Thanks. Yeah. Yeah. Josh,
Thank you, Misconduct. Thank you.
Yes, sir.
are you signing on to this case?
Am the felonies, and I had some difficulty. I guess I thought I was already on the county court case, and I realized today that I wasn't. But we just filed a motion to sub, but we haven't been able to get a hold of the court-appointed counsel this morning.
Let me see who it is. Oh, it's Sherman Hatton. Let me see if I have his phone number.
Judge, he was told by the bailiff he has a warrant out. I didn't see anything online.
He does. He picked up a new case, Josh. Mr. White did not tell you, probably?
It didn't. Is that in Harris County?
Correct. His now 5th case. That's the surprise, I guess, sometimes you get. You know what I mean? Like a kick in the ding.
Sure.
Are you ready? You want to go forward?
Yes, sir. I'm ready.
All right. Come up, Mr. White.
How you doing today, Your Honor?
Not happy with you?
Yes, sir. I understand.
We'll get to it. Everyone keep it down, please. Mr. White, you are now stand charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. So you know you have a lawyer, Josh Rice. He's here on Zoom. I don't know why the TVs aren't working, but he's here with you now, so you know that you're not alone. Do you see that motion to sum is in file in Mr. White's house? You have it? Okay, great. All right. So, are you ready?
Sir.
Go for it.
Judge, on July 21st, officers were dispatched to a family assault call in Harris County, Texas. Officers met with the complainant, who is the defendant's stepfather. The complainant stated that after telling the defendant to turn off the defendant's mother's vehicle and come back inside the home, the defendant kicked open the front door and punched him with a closed fist to the left side of his head. The complainant stated that the defendant then fled the scene in his vehicle. The complainant stated that the defendant has been staying in his residence for the past 2 weeks due to not having anywhere to stay. The complainant stated he felt pain when assaulted and wanted to pursue criminal charges against the defendant. The complainant had visible minor injuries near his left ear.
Josh keeps looking at me funny. Josh, stop.
Mr. White, I'm going to find that there's probable cause to go forward with your case. I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Mark Maple as a protected individual. You cannot commit family violence or an assault against
Have you ever seen Princess Leia and him in the same room at the same time?
this person. Commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where he lives or where he works. Do you understand?
Yes, sir.
Now, I'm also, as a condition of your bond, ordering you not to consume alcohol or illegal drugs. I'm going to randomly test you. If I find that you're consuming alcohol or dope, likewise, your bond will be revoked. You will go into custody. As it stands now, you are on bond for at least 4 to 5 other cases. One of those being an evading arrest here, which is 1,200 days old. I am now revoking that bond and taking you into custody. He goes with you. Josh.
Education
Yes, Your Honor.
is a stretch.
It looks like the felony cases are set for September 4th. Are you hired on those as well?
Yes, Judge.
Okay. We need to talk about a bond on the assault case because nothing is set at this point now. Pavel, what do you think from Mr. White?
Your Honor, I would argue, at least with regards to, he's got 3 felony cases on bond for and 1 prior misdemeanor that is from 2021. Judge, to which he hasn't shown up since August of 2021. And now he picked up a new case. That's the only case he finally got him back. I would ask for a $5,000 bond on the assault on a family member. Surety.
Judge, just some context. He went to TDC during the time between when he was arrested on this old evading, and he's already been released from TDC. And then we, he had some outstanding charges in Fort Bend that we had to, wrestle with, and
He has
we got
other
him
stuff in Fort Bend too?
He does, Your Honor. But
Holy moly.
but we're fighting and dealing with those. Many of them are old before. The majority of the charges are before he went to TDC.
Josh,
So
God bless you, man. We love you. What else does he have?
I believe he's got a burglary of a habitation charge, and
Nick is taking Josh's picture, and I want to know why.
maybe a possession in Fort Bend. I'm not sure all of them.
Maybe possession.
And I believe all of except this new one and 1 Harris County charge, all of them precede his trip to TDC. So we believe that most of them, if he is going to plead them, will be a time served. Some of them, he has alibis, and it was someone making a false accusation against him in order to get a deal on their case or something like that. So,
what I see, Judge, in Fort Bend, it was deadly conduct, discharging a firearm, theft of a firearm, and theft of property, 2530K.
All those 3 are open now?
No, they were disposed of May 17th of this year. So 2 months ago.
But Josh is saying he has open stuff.
Let me see if there's anything else that I see on Fort Bend.
Or anywhere.
I believe.
Look anywhere. Like expand your horizon, man.
It's 31 pages. Mandel controlled substance in Victoria. Tampering, fabricating physical evidence with intent to impair in Victoria.
And I guess take your time then. There's 31 pages. There's no rush.
I know. I'm just trying to go through the felonies. Evading with a prior in El Campo PD. That was 2023. It doesn't show a disposition, so I think that one's open. Let's see. El Campo PD, tampering, fabrication, physical evidence with intent to impair. Felony 3rd degree. Doesn't show a disposition yet.
I guess let me get a PSR and then I'll check it out. You mind? What's that? Got it. Hey, Casey, what you got? Come on. Oh, orange.
You had all the other ones.
And there's nothing left. I mean, this is like, really. As if my day wasn't going, This is a hot mess. And I'm going to tell you now, you have so much drama in the wake that you've left. I'm going to keep you so close to me that you're going to think we're in a darn relationship. That's how close I am. I'm going to do everything in my power to protect every single person of Harris County. And I don't care if I hurt your feelings or you get a little upset because you have to come to court a lot. You're going to be coming to me, testing so much, and you're going to be hanging out with me so much that you're going to think it's a career. Do you understand, Mr. White? As it stands now, I am going to revoke your bonds and I'm going to set them, I don't know, probably commensurate to what your felony bonds are now, because it's evident that you continue to do whatever you want without consideration to any kind of court orders. It's just to every single court. There's nothing that you need to say. What you say to me now goes in one ear and goes out the other. Actions speak louder than words, Mr. White. And you just got out of prison, and now you have you literally just got out of prison for felon in possession, and now you have an evading arrest, felon in possession, evading arrest, another felony evading arrest, and now you've picked up an assault of a family member. It's over. What else did you have to say?
Judge, so I do see some of the offenses do predate his TDC trip. The ones that predate, it looks like he has a Berg cab that's active in 2018 out of Richmond, so Fort Bend.
So that's still open now?
I don't see a disposition at all in that case. UUMB and burglary of a vehicle out of Rosenberg, so I believe that's still Fort Bend.
But now that makes 8 cases open.
And those are before his TDC trip. And I see on the burglary of a vehicle, not the other cases, that there is a warrant out. He absconded. So after he went to, and he has a warrant.
So that's an open warrant now?
Yeah. And
Josh, did you know about that?
And where is that out of?
So this is the burglary of the vehicle, Fort Bend County Court of Law 2.
We just appeared in Fort Bend and they didn't say anything about that, but I will figure out what that's about.
Maybe they resolved, this is what I read as of today. Maybe they just haven't updated this, the criminal history yet. He has an evading with a prior out of, let's see. It shows pending, but it also shows a disposition date. So I'm just going to disregard that charge. It doesn't.
Is that Fort Bend as well?
Fort Bend, Richmond. Yeah, so Fort Bend. It's 240th District Court. With regards to his open cases, he has tampering, fabricating physical evidence with intent to impair, 3rd-degree felony, Rosenberg, possession of a controlled substance, interference with public duties, and then the Houston cases. Let's see, burglary of a building, Fort Bend again.
What we're going to do now.
That also shows absconded, but he may have posted those two.
I'm going to let you go back. I'm going to let you talk to your lawyer. Before you start saying stuff to me here, I want you to speak to your lawyer so you guys can decide on what you want to say, because I don't want you to say anything that hurts your cases as it is. What I'm deciding now is how and what to make your bonds at. That's what I'm deciding now. So before I set a monetary amount, I want you to be able to talk to your lawyer, you guys powwow, and then I'll bring you out and then we can talk. Okay. I'm sorry, go ahead.
He has 2 cases out of El Campo and I think another 2 cases out of Victoria.
So he has another 2 cases open and elsewhere.
So the El Campo cases that I see are evading with the prior, tampering, fabrication, physical evidence with intent to impair. And then the ones out of Victoria, Mandel, controlled substance, PG1B, less than a gram. So 3rd-degree felony there, and then just possession of marijuana. And that's it. That's all I can find.
Okay, so Josh, let's go back. I'll have you talk to Mr. White. I'm telling you now that for me, it's going to be in the quintuple digits. Okay. It's just a matter of how much. I mean, being that, I don't know, what did I hear? 8 cases, 10 cases, give or take, something like that. We don't even know how many I don't even know if you know how many open cases you have. All I know is that where you go, trouble follows. So hold on. I'll let you talk to your lawyer. You decide what you want to tell me, and then we can bring you out whenever you guys are ready. Should he call the 2689 number? Okay, so just go back and then Josh, I'll give you the number now, and then just call back there, and then when you're done, just pop back in and we'll talk. Okay?
Yes, sir.
Hey, I'm going to chat you the phone number, Josh. Okay?
Okay, perfect. Thanks a lot, Judge.
All right, we got you.
Awesome.
So, good morning,
Oh,
Your
was
Honor. I'm
that
present
it? Was that the last one? Yeah, that was the last one. Hold on, hold on. I want to show you guys something else. There it is. So at the end of the stream, the judge sits and talks to everybody for a little bit. Not every stream, but a lot of the streams. And he calls a lot of us out. So I thought I would play the end with him and Victoria when he's looking at chat and talking to chat.
You want me to give it to him? Too late,
Why does he want to call me?
because you're a son.
Oh, we missed that part.
Everyone's saying hello to you, Ramona.
Hi, Ramona.
Hello. I'm logging on now.
So that one guy who can't see, he comes back. We'll see him on Saturday when I play the second half of this clip.
Keychains. Oh, yeah, keychains, lanyards. Oh, both.
They're talking about merch.
Problem is that I don't know if we would get in trouble for doing it. That's
What
why.
about during election time?
No, I
Yeah,
didn't
during
call
election
Judge
season,
Simpson.
yeah, which is probably coming up pretty soon.
It
Oh,
is.
oh, no. Election season is probably coming up pretty soon. At that time, we'll definitely have stuff going around.
Merch, guys, merch.
Mhm. I can start selling.
Does anybody here live in Harris County though? Everybody's like elsewhere.
They
you
would
know?
wear your merch anyways.
Facts.
No, it's not here.
RSAP 331, get on it. Oh, it's VSAP.
Excuse me.
What's the leanest clip, Ozzy? Give me a time and I'll play it.
Oh, yeah, look, mouse pads, bow ties, coffee.
Yeah, but there's,
posters.
I know I have to reach out to the ethics commission to see what we can do, what we can't do.
Yeah.
Oh, that's probably a good idea.
Bow ties, definitely.
But during election time, I think that'd be different, you know? I'm just kidding.
I like that, Ardo.
Is Colin here? Is Colin still here?
I don't know. I'm barely able to look at chat. right
A
now.
lot.
Yeah. You know, there was something interesting that happened earlier
A
where
lot.
a lawyer posted a bond for a defendant. And I got to say that just, especially with someone as many that cases as that, that's just a very
I'm in
dangerous
the wrong
proposition. 'cause,
program. Looks like it.
You know,
Maybe
Hold
they
on,
put something up for collateral.
He calls everybody out. I'll play that as soon as I play Fozzy's clip. And now I'm in a loop.
it's okay, so Lena's.
Lenin.
Okay, well, that's good to know.
Okay.
Great. Well, thanks for telling.
Yeah, it's the Dutch way.
How do we pronounce Venus?
You know, we need to know some Dutch bad words. That way we can say it in court.
Oh, yeah.
That way, because I've been using German and we need some Dutch words. So, Lena's, give us some good Dutch words to use when we get upset here.
Yeah.
It's okay, so Lena's.
Lenin.
Okay, well, that's good to know.
Venus said she's going to work
Well,
on
thanks
that.
for telling.
I probably got that. It's probably coming right up. We're probably going to have to watch it twice now.
I mean, theoretically, anyone could post a bond for anyone, right? It's just you're going to be on the hook if they take off or do something.
He does start calling everybody out. He does. He does. First they talk about merch, then he just starts randomly talking to people. Yiddish. He could use Yiddish.
With judge's face on it.
Oh, Lord.
I was not the first. I said Linus, and right away she told me. Yes, he really does. We're gonna see what he did for that one guy on Saturday.
I like what was there. John, I have a great idea.
What's that?
Merch. We have like a teddy bear. And when you squeeze it, it could be your phrases. Like, you're gonna be stuck like Chuck and Jay.
Victoria just said we could get merch with the teddy bear, and when you squeeze it, it's his favorite sayings.
I want them to think about it. That's why I asked, you know? I want them to think about, hey, how was jail? I want them to have a bad time. Hopefully then they'll reflect. Some people just don't get it, you know?
He's not saying it.
All right, guys, we're gonna log off.
But he's not. He said that, but he's not. Not for another 4 minutes. He's gonna talk for 4 minutes. First he asks, out of everybody in chat, he asks Jasmine how old she is. He thought she was old. No. I'm sorry. That's not what he asked. He asked Jasmine, what does she do for a living? We were all like,
Just what did you do about
school.
the VPR on Wednesday? Mark.
Tracy,
You said it for Monday.
we're busy. Leave him alone.
On McIntyre?
Huh?
You said it was McIntyre, right?
No, Mark Lindsay. It was.
Or that, okay, Lindsay, yeah. I think that's what it was.
I mean, in May.
Yeah, and then we're
did not
just now
graduate
getting
in
it.
middle
I
school.
mean, that's, come on, we got to get on Jeremiah.
have
Huh?
middle
Is that
school where I
Jeremiah?
went.
Is that Jeremiah?
It's grade school and high school.
Yeah, the bond violation was in May. We're just now getting it 2 months later. Isn't Jeremiah?
That's all I say then.
Okay, no, that's not that one. Don't be putting his name out there like.
No, someone's dropping the ball. I thought,
It's not Jeremiah.
who's helping us?
I'm gonna ask why it took so long.
Yeah. How are we supposed to monitor someone if we get the alcohol test 2 months later?
Was.
You know what I mean?
Jeremiah was a bullfrog crystal.
I don't know. We'll get it. Yeah.
Yes. Another Kathy. Gotta love that.
Evelyn Sauceda.
Well, Kelly probably ate them thinking it was an alligator that tastes like chicken. I'm gonna bump it up till he starts talking. Oh, this isn't. He is talking. We just need another second. He's talking in chat.
Do you ever get up at 4:30 in the morning?
Yeah, yes.
Really? You guys log on at 4:30 to hang out?
Yes, they do.
What time do you go to bed?
Don't even ask.
So
You don't even go to bed, do you?
Sometimes. Last night I went to sleep at 2.
2 in the morning,
Yeah.
and then you got up at 4:30?
I know I got up at 5. This time, 5:30. I didn't log in.
Whoa. Do you take a nap?
I do.
Okay.
See, naps are cool. It's for the cool kids.
What time do you go to bed?
Probably like 10.
Hmm.
But I only get to nap if the baby naps, so I like try to convince her that she needs a nap.
Even if they just said, I just want to give them something.
We are grateful to have them.
It looks like they were changing officers from that time, but I.
Hey, there's
Turnover is so
Victoria.
bad over
Hi,
there. It's just
Victoria.
ridiculous. That's why. Yeah, Linus, I'm with you.
I like
One of
your
these days,
idea,
we'll get up
Victoria.
at 4:30 to join. I don't know, is it Linus? I mean, how are we gonna know? We can't
Nope.
hear.
We're watching this all again because of
Are you
fun.
gonna phonetically spell it? I don't know. How otherwise are we gonna know?
All right, is it Linus?
See, Victoria knows.
Type 1 for yes.
Wait.
Or Linus. Type 2.
You need to
Wait,
get some sleep,
Let me
girlfriend.
see what happens.
Okay, say it again.
Linus. Like Lee. She could hear us, Judge.
Victoria,
Okay, I
did
said
we
one
find
or
out
two.
what his name is
Linus,
yet, other than
Linus.
trainee?
Victoria says it right.
So
Booyah.
Okay,
Linus.
look how Kathy says Linus.
Yeah.
It's
You were saying Linus.
it's the okay. So Linus.
Linus.
Okay, well that's good to know. Great. Well, thanks for telling me.
Yeah, it's the Dutch way.
Trey.
I
Hey,
mean, we need to know
Trey.
some Dutch bad
Hi,
words that way we
Trey.
can say it in court.
Oh, yeah.
That way, because I've been using German and we need some Dutch words. So, Linus, give us some good Dutch words to use when we get upset here.
Yeah. So
You know.
message me in Discord, all the good cuss words.
Yeah, put it in the Discord, huh?
Oh, yeah.
That's her first assignment as a mod.
Linus got mods
right.
today.
I'll
In
see you
Dutch
tomorrow.
Fleischer's
Bye.
chat.
Okay.
Linus is not here, but Linus also got mod today in our chat. Well deserved. Linus was in Wolf's stream too. So yeah, she needs some sleep.
All right, she's gonna make us a list. Wonderful.
Sounds good.
Because
Now you have to learn how to pronounce it though.
I was watching a judge the other day, and he was just cussing in court, and I'm like, whoa.
Judge
He
O'Donnell.
didn't disguise it at all?
No, he said, he said the S word, and I don't know. I mean, would I get in trouble if I start
You're the
cursing in
judge.
court? I don't know, but I don't know if I want to take that chance.
Yeah.
Don't do it. Don't do it.
Ramona.
She's a good angel on
Don't
I mean,
do it.
Would we get in trouble, Ramona? I mean,
I don't know. Just don't do it.
Yeah, just leave the cussing to me. I'll do it.
I mean, I know that there's a canon where you have to be like respectful and and I don't know. I'd have to look it up.
So you want to be known as the cussing judge?
Yes.
No.
Yes.
No.
Absolutely.
No, because I don't know how much it really helps, right? The idea is to get an idea across to a defendant somehow. And you just got to bring it
I
down.
think you can do it without using profanity. You've done that thus far without using profanity.
Right.
Okay, that's too much logic, girl.
Well, in different languages.
Well, if they don't speak the language, they don't know.
There's more.
Yeah, Nan.
Yeah, Nan. I might as well post your comment because the judge said, yeah, Nan. Yeah, fun police.
This is then for monopoly board and sign on the bill. Put his autograph in it.
Well, she could send the get out of jail free card to Judge. You can sign those, Judge. Print out a bunch of Monopoly get out of jail free cards and sign them and send them out.
You mean to defendants?
No, like
to me.
you know,
I want one.
Monopoly
I want one.
cards.
I would get one.
Oh,
That would
well,
be fun, just
well,
to send them out for fun.
He's
All right,
in with
guys.
that idea. I love that
We're
idea.
gonna log off. It's been real. Thanks for
Bye,
hanging out with us.
legal. See you,
Bye,
legal
Victoria.
fiction.
Thanks, American
Bye,
Courts.
Melissa. Bye, Ramona.
Bye.
Bye,
Oh,
Fred.
and Bill,
I haven't seen Lone. So
he
Lone
was
here
there
today?
earlier. He probably can hear us.
And hey, to your mom, it's Rasher, right? Is
Yes.
it Kathy Rasher?
Karen
Karen.
Brasher.
Sorry.
Karen
Hello,
Brasher.
Karen.
Here comes.
Hey, legal.
Legal.
Todd,
Todd.
Good
Todd.
Todd. That's the good Todd.
Tokyo.
Jag 731 said stuck like Chuck is a curse word.
No, that's not exactly right. Hold on, I'll tell you later.
Is it a curse word? Maybe.
Which one, Ramona?
Stuck like Chuck.
No, man, that's not a bad word. Come on. That's nothing. Yeah. All right. Bye, everybody. We'll see you tomorrow.
I thought he
We'll see,
did
or
more.
we'll see you in the Discord, actually.
Yes, Kathy's Discord. Court vibes.
And then bye, Colin. Bye, Vicky. Bye, Rochelle. Steve N. Brasher, B-Sav, Twitchy, Jasmine, Mike M. Everyone, we love you. Thanks, family.
So then, let me get rid of this. So Ramona read that, but it wasn't right. So what happened was Victoria and the judge were asking for Linus to translate bad words into Dutch. And Jag wanted stuck like Chuck translated into Dutch. And Ramona saw that while they were talking about the swear words. But Linus has to do that. Linus has to translate that just to Dutch, the Dutch way. Yeah. Yeah. I mean, he's so awesome, Victoria. You're so lucky. You and Melissa are so lucky. My boss is a beep. Beep, 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 beep. I got the reference. Romper Room. See, I was looking for everybody. All right, guys. I'm not going to do any strangulations tomorrow unless I want to. I got to give you what I get, guys. I can't just order up a Karen or a Sav sit. I get what comes in front of me. It's like fishing. Uh, you could probably Gaelic. Did you get us some Gaelic? Thanks for coming, John. Thanks for coming at this really, 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 really weird time. Thanks, Fozzie. Thanks, Misconduct. Oh, mods, thank you so much for all your help. Although, you're needed, you're absolutely needed, but you're not needed for what you're here for. Nobody really misbehaves that much. That's awesome. And it's fun. It's fun. That guy yesterday, okay, the day before yesterday or whatever day, was like the Biden administration did this to me, and I'm in Fleischer's chat, and I'm like, okay, this is not my channel. So I just let it go. But you guys rolled with it. You guys were awesome. And now nobody's mad at anybody else. No, except for Kelly and Donald. But they'll be all right. Oh, you don't have to get up at 4 a.m. You can just watch what you watch and watch us later. I can't. Oh, Chris almost got me singing. Kelly almost got me yodeling. See you guys later. Behave, okay? Behave. Yeah, exactly. Exactly. Bye, guys. Thank you. Thank you. Have a good day at work, Victoria.